फ्रेंड्स, वेलकम बैक टू माय चैनल. इफ यू आर न्यू व्यूअर प्लीज सब्सक्राइब माय चैनल फॉर मोर वीडियोज. आज हम बात करते हैं एक ऐसे जजमेंट की जो है एडवोकेट्स ऑफिस रन फ्रॉम रेजिडेंस नॉट सब्जेक्ट टू प्रॉपर्टी टैक्स एज बिजनेस बिल्डिंग्स. दिल्ली हाई कोर्ट ने ऐसा कहा है. होल्डिंग दैट द प्रोफेशनल एक्टिविटी ऑफ लॉयर कैन नॉट be seen as commercial activity. The Delhi High Court held that an advocate office run from the residential building is not subject to property tax under the Delhi Municipal Corporation Act as a business building. The division bench of Justice Najimi Waziri and Justice Sudhir Kumar Jain noted that the master plan for Delhi MPD 2021 permits professional activity residential buildings subject to certain conditions. However, the said provisions of MPD did not empower the corporation levy tax for professional activity being carried out the residential buildings. The divisional bench was dealing with an appeal filed by the South Delhi Municipal Corporation SDMC against judgment of the single judge, which held that services rendered by advocates are professional activity and hence they cannot be classified, categorized and subject to tax under the category of business establishment. The issue arose in 2013 when the STMC issued notice demanding property tax to a lawyer who was running his office in a portion of his residential premises. Allowing the lawyer challenging against the STMC actions, the single bench had observed, in the opinion of this court, a premises would not become business premises just become a lawyer read his office file and did some official work at his residence. Arguments of MCD. The MCD had the power of levy property tax on all lands and buildings under its jurisdiction. Therefore, unless consequently exclude, there cannot be any buildings, property and activity that cannot be taxed. If a building or part of the building is used for the transaction of business or the keeping of books, accounts and records, it shall be considered as a business building and therefore subject to a levy of property tax. A lawyer's services fall within the shapes of professional activity and a part of a building that is used for professional activity would fall within the definition of the business building. Activities being carried out by the advocate professionals are commercial and non-domestic in nature. Therefore, it is subject to tax simply because such activity is carried out a residential premises as per permitted users under MPD 2021. The activity would not become residential. MPD 2021 approves professional activity does not in any way circumscribe the power of the corporation under section 115 and 115A of the Delhi Municipal Corporation Act 1957 DMC Act. Respondent arguments. The respondent contends that the power of tax must be expressed. Otherwise, there is no power to tax. Under the DMC Act, there is no power to tax professional activities carried out of residential buildings. Discharge of professional activities by advocate, not business. The court, while upholding the ruling of the single bench, held that the professional activity of lawyer did not fall within the category of commercial establishment or business activity, and the firm of lawyer is not a commercial establishment. It referred to a judgment of a divisional bench of the Bombay High Court in Sikkim, Sakharam Narayan, and the case of which held that the discharge of professional activities by advocate would not be covered under the expression business, nor would it the professional establishment, because the word establishment would only refer to as a shops as defined in the Bombay Shops and Establishment Act 1948. Reference was also made to the Supreme Court judgment in the professional activity of the lawyer does not fall within the category of commercial establishment and business activity, and the firm of lawyer is not a commercial establishment. Taxation power have to specifically mention. Reference of Supreme Court precedent of the bench state that taxation power have to be specifically mentioned in the situation of, and they cannot be inferred and presumed. Hence, the arguments of MCD that a lawyer office should be construction as a business establishment was rejected, as there is no such deemed provisions in the law. Under the DMC Act, there is no power to tax professional activity carried out for the residential buildings. Professional activity are permitted under MPD 2010. Under certain conditions, the master plan has force of law. The language of section 116A, subsection A of the DMC Act 1957 does not include tax on professional activity. Is observed. The court held that professional activity by lawyer will not come under the ambit of clause 9 AB and subsection 1 and 2 of the Delhi Municipal Corporation Property Tax by Laws 2004. In this case, ये केस टाइटल है साउथ दिल्ली म्यूनिसिपल कॉरपोरेशन वर्सेस VN मागोन. काउंसिल है काउंसिल संजीव, जो संजीव है वो है उनके काउंसिल. तो ये केस था कि जो एडवोकेट का जो परमिशन, जो कोर्ट जो एडवोकेट्स हैं वो क्या करते हैं, जो उनका ऑफिस होता है वो घरों में होता है, तो उस पर एक वकील से क्या है टैक्स मांग लिया गया, तो उसके अगेंस्ट क्या है ये सारा केस है. तो फ्रेंड, ऐसे ही अपडेट्स के लिए प्लीज़ सब्सक्राइब माई चैनल. थैंक यू फॉर वॉचिंग दिस वीडियो.